back to Winning Law. I'm attorney David Nguyen with offices in Houston, Texas. And today we're going to talk about USCIS Form I-290B, which is Notice of Appeal or Motion. This form is used when your case is denied. Now, before we start talking about the form, let's talk about what is an appeal and what is a motion to reconsider or a motion to reopen. An appeal is a request to a different authority to review a decision. A motion to reopen is a request to the office that issued the unfavorable decision to review its decision based on new facts. And a motion to reconsider is a request to the office that issued the unfavorable decision to review its decision based on incorrect application of law or policy. Our office has experience handling appeals, motions to reopen, and motions to reconsider. And today we're going to discuss some of the cases that we experienced dealing with these issues and how we were able to resolve them. Now, before we go any further, I want to give a warning to anyone that's watching this video. If you're watching this video, most likely your case has already been denied or that you have a feeling it's going to get denied. If you have a feeling that it's going to get denied or the case was already denied, read that denial notice very carefully. At the bottom of that notice, it will tell you that you have 30 days to respond or file for the Form I-290B. So if you have been doing this yourself, or if you hired someone that you're not confident in their skill level, make sure that you hire an experienced immigration attorney as soon as possible. The more time that you give an attorney to work on your case, the higher chances that you'll have in getting your case approved. So if your case is denied, remember, you can file an appeal, a motion to reopen, or a motion to reconsider with the Form I-290B. Let me give you some examples from real cases that we have encountered with our office. Now, one case that we handled involved a daughter that was applying for a green card for her mother. So her mother entered the U.S. on a visitor visa, and once she entered the U.S., her mother had a change of heart and she wanted to stay permanently in the U.S. Her daughter filed a green card application for her, and the case received a request for evidence, and then it was denied. So they came to our office because they wanted to file an appeal or a motion to reopen. We handled the motion to reopen. There was an issue with the mother's birth certificate, and we were able to get it resolved for providing the government with new information. Again, a motion to reopen requires new information or new documents. So that was an example of a case involving a motion to reopen. So now let's focus on a case involving a motion to reconsider. In the last couple of months, a couple hired us because a woman filed a green card application for her husband. After the interview was done, they received a notice of intent to deny, or NOID. In that notice of intent to deny, the government stated that they did not provide sufficient documents to establish that they have a legitimate marriage, and also some of the statements that they made during the interview were inconsistent. They hired us to respond to the NOID, and after we responded to the NOID, the case was denied anyway. In the denial, the government did not say that they didn't submit enough bona fide marriage documents. Instead, that denial simply stated that the foreign national or the husband was not eligible to adjust status because he came into the U.S. on a C-1 transit visa. So what we had to do is that we had to file a motion to reconsider and the Form I-290B, and we had to write a brief and explain why this person was eligible to adjust status in the U.S. because there was a special exception in the law that benefited his case. So after we did this, I could tell you that the case was approved and that person right now has a green card. So as you can see, the government does make mistakes and they do sometimes offer you a second chance. So hopefully these two scenarios will help you understand the difference between a motion to reopen and a motion to reconsider. Remember, a motion to reopen occurs when you have new facts or you have new documents to provide to immigration. And a motion to reconsider occurs when you believe immigration misinterpreted the law and you need to explain to them that they made a mistake and that your case should be approved. Again, thank you for watching Winning Law. If you found this video helpful, go ahead and click the like button below and let us know. If you want to be alerted for future videos, go ahead and hit the subscribe button. That way you don't miss out on future videos. Again, thank you for watching Winning Law, and we hope that we have made immigration easier to understand.
David Nguyen. USCIS Law Office. We are here to help you. We bring families together through immigration. And on the other hand, we help you find solutions. All your legal needs in the hands of people who care, who are there for you. We'll take care of your loved ones at the law office of David Nguyen.